Before we start the session, I would like to acknowledge that Legal Aid BC and Law Foundation head office is situated on the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. I would also like to acknowledge that many of you are joining us today from many places near and far, and acknowledge the traditional owners and caretakers of those lands. Again, welcome everyone. My name is Baljinder Gill. I'm the Community Training and Outreach Coordinator with Legal Aid BC. Welcome to today's session. Today's session is a meeting, it's not a webinar, so all the questions and answers are going in chat. I will be monitoring the chat and I will read the questions to the speakers as the time permits. Also, today's session will be recorded, so you can check it later on a later date if you need any information, or if you missed any information, you can check it afterwards as well. So on this note, I will welcome our wonderful speakers today, Kevin Love and Danielle Sabelli. Kevin is a lawyer in class community law program, working primarily in the areas of mental health and workers' rights. Kevin has represented clients at all levels of court, both federally and provincially, including the Supreme Court of Canada. Prior to joining the community law program, Kevin worked in class mental health law program, representing clients who were detained in psychiatric facilities under the criminal code. Kevin represents class on a number of committees, including WorkSafe BC's Policy and Practice Consultative Committee. Kevin chairs the Workers' Compensation Advocacy Group, which is an independent network of worker advocates throughout British Columbia. Kevin acts as the supervising lawyer for the First United Church's legal advocacy program in Vancouver, downtown East Side. Along with Kevin, we have Danielle Sabelli today. Danielle Sabelli is a lawyer in the community law program at CLASS and works primarily in the areas of income assistance and residential tenancies. Danielle has provided representation to clients at various administrative tribunals and the BC Supreme Court. Prior to joining CLASS, Danielle worked as a legal advocate at First United Church, providing legal assistance, advice, and representation to low-income and vulnerable people in the downtown east side of Vancouver. Danielle holds a master's degree in social justice and communications from the University of Windsor, and was a founding member of the interdisciplinary art collective Broken City Lab. Please join me to welcome Danielle and Kevin Love, and welcome to the session again.
Great, hello everybody. Can everybody hear me okay? Great, and I assume I'm seeing people are still joining, but I'm assuming I don't need to be the one working the front door here. I'm assuming Kyle, I can just keep letting people in as they trickle in this morning. So, so what we're here today to do is to give an update on where a lot of the COVID changes are, a little bit about where they're going. I believe the session's called a post-COVID update, although I don't know if the word post really describes where we are with this thing just yet. But nonetheless, even as this the pandemic continues, there's been a lot of legal updates, and hopefully we can give you a little bit of a sense of how those work. So the way we're going to structure it is, I'm going to start by covering off all things federal benefit. So this would include EI, the various recovery benefits, and then a little bit about how they might interact with some of the provincial benefits. And then Danielle is going to cover off primarily the housing changes, where we are and where we might be going. So let's dive in. So the way I've set this up is I've set it up as for each benefit, a list of things you need to know. I figure people tune out pretty quickly in these things, so I'm just going to give you the highlights and dive right in. But as was mentioned, there is a few little deeper into anything or something doesn't sound like it's making sense, just post a question and I'm happy to go a little deeper into that. So we'll start with employment insurance. So I think most people are familiar, at least generally, with what employment insurance is. It's a mandatory insurance scheme that insures employees if they lose work for reasons beyond their control, or they need time off work for certain specific reasons. And we'll start there. And I'll just say one of the key things to understand, we're going to talk about different benefits. Employment insurance primarily targets your clients, and it'll probably be most of them, who work as employees, who work for somebody else. When we come to the other recovery benefits, they're primarily targeting the growing number of people who aren't covered by the employment insurance system, which was a real problem. So in a nutshell, that kind of explains these two sets of benefits and who falls into what category. So, drum roll, the number one change that people need to know about, and this one is wonderful from a simplicity point of view. It now takes 420 hours to qualify for EI benefits in all places, everywhere. In Gander, Newfoundland, in Victoria, BC, doesn't matter. It's now 420 hours. Whether you want sickness benefits, whether you want regular benefits, whether you want parental benefits, it's just 420 hours. So when your clients ask you for the next year at least, how many hours do I need to qualify for EI? You have a very simple answer, which is nice. The downside is this number is higher than the temporary measures that had been in place for most of the year. As people will recall, through a complicated system of credits, that number was actually down at 120 hours for a while. We knew it was going to go above that. Was hoping, maybe we'd keep it down in the 300 somewhere, but nonetheless, 420. It's still the low end of the current range that would ordinarily be in place, and it's simple and it should facilitate access for many people. So again, this is in place for about 1 year from now. We're hoping, and as I'll come to later, that we can use these as a springboard into permanent change. But for now, this is only in place for claims starting before September 24th, 2022. So the second change is the minimum EI benefit. So no matter what you were earning before, if you start your claim between September 26th and November 20th, you're going to get a minimum benefit of $300. So this is good. It's really good to see a minimum benefit. Some people will say, well, that looks a little lower than the $500 people were getting through the pandemic. And it is. So that's a little disappointing that it's gone down. But nonetheless, for those clients who are very low income, there is going to be that minimum floor of $300. But that only applies to people who start their claim before November 20. After November 20, we're back to the usual rules of 55% of your average weekly earnings, which isn't a whole lot, particularly for low-income people. Number three, there were wonderful extensions that gave everybody up to 50 weeks of benefits, no matter how many hours they claimed with, no matter where they lived, and that was fantastic. But unfortunately, that is no more. So there is no more 50 weeks for up to 50 weeks for everybody. We're now back to an ugly chart for those of you who've seen it before. It depends on two things. One, how many hours did you work before you qualified for EI, and the rate of unemployment where you live. And the number of weeks you're going to get is between 14 and 45. So if people are sort of shaking their heads saying, you just said everybody only needs 420 hours to qualify, and that usually depends on the rate of unemployment, but this seems confusing. You're right. The rate of unemployment where the person lives does not affect how many hours they need to qualify, but it does affect what they're going to get once they get through the front door. And now it's going to be between 14 and 45 weeks. I would note there is one change that I haven't mentioned in here, and it's a program for seasonal workers, which would ordinarily be relevant to a number of you, but I don't think it applies to any of the regions in BC. But if I'm wrong about that, it provides extra weeks for seasonal workers, but I don't think any of the BC regions are covered by this program. But if I'm wrong about that and somebody has been getting these extra weeks for their seasonal clients, you can post it in the chat maybe and let me know. Number 4, the 1-week waiting period is back. So this is kind of the EI system's idea of a deductible, that the first week of unemployment is on you. It doesn't really make a lot of sense, but it is what it is. During the pandemic, to speed people along, they had been waiving that 1-week waiting period in most cases, but now it's back. So your clients are going to have to serve a 1-week waiting period, being the first week of their claim when they apply for benefits. Number 5, claimants once again are going to need a doctor to fill out the EI sickness benefits form if they want to collect sickness benefits. So this had been waived for good reason. During the pandemic, we didn't want people who were pretty sure they had COVID to go into a doctor's office and spread it to everybody just to get a form filled out to access EI. So that requirement had been waived, but now it is back, and your clients are going to have to fill out this this form. When we come to the recovery benefits after this, I'll note that for those benefits, there is also a sickness benefit for people falling outside of the EI system, and I don't believe that does require anything from the doctor, but the EI system does require a note from your doctor to access sickness benefits. Number 6, and this is a change. It hasn't happened yet, but before we're all together again, hopefully in person next year, it will be in place, assuming all the people who have promised things keep their promises. So we shall see. EI sickness, the plan is to extend it to a maximum of 16 weeks in the summer of 2022. Currently, the maximum EI sickness benefit is 15 weeks. So obviously for people who have serious illness, that's not a lot. We were hoping to get that number up above 26. That didn't happen, but you know, 26 is a good start. At least it's an extension of some kind to the amount of sickness benefits that people can get. But again, that's not in place now. That will be in place ideally sometime in the summer of 2022. Number 7, separation money. This is stuff like severance or pay in lieu of notice, employment standards type stuff. That's not going to be deducted from EI, and it's not going to delay the start of benefits. For those of you who have done some EI before, you'll remember this complicated song and dance where people would get severance or pay in lieu, and then it would be, you tell the EI people and they just take back the EI benefits, or you'd have to apply for EI, but you couldn't collect because you had to wait for your severance to run out. At least until September 24th, 2022, that's not going to happen. Severance money, pay in lieu of notice, not going to impact EI claims. And then number 8, quitting or being fired for misconduct only matters if it was your last job. And I'll explain a little bit more about what this one means. So if you quit your job or you get fired for misconduct, the EI system has traditionally said, hey, that's your fault, not an unforeseen circumstance, so we're not going to cover you. But this is a really harsh penalty for a lot of people. And to make it worse, under the old rules, the way it worked was, if you quit your job or you get fired for misconduct, they basically draw a line through that date and you lose all the hours that you collected before, and you have to reaccumulate all your hours after that date. So I would like to see these rules gone altogether, but we do have a good positive step here, which is all that's going to matter is the last job. So let's use an example here. Somebody, so somebody is working and they accumulate, let's say 500 hours, which right now is enough to qualify for EI, but they quit their job and they're found that they don't have just cause. Well, EI is not going to let them, it's still not going to let them have any EI benefits. But if that person goes back to work and only accumulates 100 more hours and then gets laid off for no fault of their own, they will now qualify because they don't go back to zero. They would have a total of 600 hours, which would be enough to qualify. So as long as the last reason for losing your job is a valid one, you're good. You don't lose all your hours. That one's a little bit complicated, but I hope that makes some sense to folks there. Fishers, and I admit I don't know a whole lot about EI and Fishers, but I know for our friends up in Prince Rupert and other places on the coast, it is a big deal. So I hope I don't get this all wrong. So there's been corresponding reductions to people in the fishing industry, self-employed fishers. They can now, because they qualify based on earnings, not based on hours. So that's down to $2,500. And until December 18, you're allowed to qualify using your earnings from either the current fishing season or any of the last 2 years. That correspond to the same season. I gather there's a winter and a summer season, and for the same season you can go back 2 years and use that to qualify. And lastly, on the EI front, there is a more comprehensive review of the EI program going on right now. This is an old dinosaur of a social program, hasn't been updated, a lot of workers falling through the cracks. So if you or your organization have an interest in EI and particularly how it impacts the clients you serve, maybe give some thought to participating in this because it is a very important social program, and we've got a chance here to make some really good changes to put it on the right footing. So that is the 10 changes to employment insurance. You'll be very happy to know there are only 4 for the recovery benefits. But Baljinder, I'll just pause to see if there's any questions or anything, or if I should just keep going through.
There is one question here that says, can a client assume he remains eligible for EI if the online reporting system gives him a new date 2 weeks down the road for his next reporting date?
Okay, so I'm not, hopefully I've understood the question here. Yes, EI requires reports every 2 weeks. So if you submit one report, I imagine there's a very good likelihood that they're going to tell you to submit another one in 2 weeks. And I wouldn't expect that to be a problem. For some people on parental or maternity benefits, there is a way to not have to file reports every 2 weeks and just say, I'll tell you if something changes. But for everybody else, there is a requirement to file every 2 weeks. So you do want to make sure the first report got filed okay and didn't create any problems. But the fact that they're telling you to file another one in 2 weeks is not a red flag. That's standard for everybody. So I hope that answers the question.
Great, and that was it. Feel free to go ahead.
Great. Okay. So the Canada Recovery Benefit, that should actually say Canada Recovery Benefits, because there is a Canada Recovery Benefit, and it's a parallel benefit to EI for people who are self-employed or otherwise fall outside the EI system. But there's also the Canada Recovery Caregiver Benefit that's available to people who have to take care of children or dependents for reasons related to COVID. So this could be things like school closures, interruptions in a family member's usual care because of COVID, these kinds of things. And then there's also the Canada Recovery Sickness Benefit, and that provides up to 4 weeks of benefits for people who either need to miss work because they have COVID or because they need to isolate. So I've structured this as an update, not to bore you by going through the nuts and bolts of each and every benefit. But I can say that if you, there's lots of information on these benefits online. So if you're not as familiar with the entrance requirements, it's easy to look up the entrance requirements and sort of see specifically what a client needs to do to get on any of them. But in terms of changes, there have been some. The first and perhaps biggest is that it's ending. So the last payment period ends October 23rd, 2021, which is coming up. We just had an election. I don't know. I'm not up to date on all my political gossip. I don't know if this date is going to get pushed back, but right now, the Canada Recovery Benefit, the suite of benefits is scheduled to wrap up after October 23rd, which could be a bit of a shock for some of your clients who have been relying on this for the past year and then CERB before that. However, EI with its slightly more friendly entrance requirements will still be there for people who do have some work hours. The Canada Recovery Benefit. So this is the one, not the sickness benefit, not the caregiver benefit, but the one just for people who were self-employed or otherwise working outside the EI system and just couldn't find work or had a more than a 50% reduction in work. That benefit is now only paying $300. Previously, CERB and the Canada Recovery Benefit that replaced it for the last year had paid $500. So they're tapering down the they're tapering down the benefit level. And that's this one is a flat rate again. Unlike EI, you can't go higher. So when EI, when they have a $300 floor, you can get more than that if your earnings are higher, but you can't get less. Here, the $300 just is what it is, what it is. It's what you get. And this will be an important change, at least in the next couple of weeks for people. For people who are exhausting their EI claims, and by exhausting their EI claims, I mean using up all the benefits that they qualified for. You can now use your EI, the money you got from EI, to qualify for the Canada Recovery Benefit after your EI benefits have run out. So people may recall that for the Canada Recovery Benefit, unlike EI, you qualify based on dollars earned. You needed $5,000 to get on the Canada Recovery Benefit. Well, they've changed it that any EI you got after September 27th, 2020 is going to count as towards the $5,000 to qualify. So even people who have no other income whatsoever outside of their EI may qualify for a few extra weeks here as we roll down the program from the Canada Recovery Benefit if their EI benefits run out.
Kevin, there is a question for you. It's a clarification. It's if the online EI reporting system says you can report again in 2 weeks, the client can assume he remains eligible as long as the online system continues to tell him report in 2 weeks. The client does not have to do his own eligibility assessment if the online system tells him he can report again in 2 weeks. I just need some clarity on this.
Okay, so there's no way for me to say without actually knowing all the facts whether a particular client is or is not good to go from an EI perspective. But at a general level, I can say this. EI works in large part, and especially now, on a self-report system. So you are reporting information to EI. And so no, the client doesn't have to do their own assessment per se of whether they're eligible or not, but they do have to report all the information that would allow EI to make that that assessment. So so again, the way it works is that those online forms aren't an assessment by the client of whether they qualify necessarily. They're just giving the information that's going to allow EI to do it. So once you've sent off the information, EI is going to look at it at some point, unfortunately, sometimes long after the benefits are actually paid, and make a decision. So I think what the system is telling you is, thank you for submitting your information for this 2-week period. We've got your information. We'll run it through whatever checks we run through, and they're pretty far and few between right now, but they'll run it through whatever checks they need to determine eligibility. And I think what they're saying is, thank you for providing your information. Please do it again in 2 weeks. So I think what that is telling you is, please continue to report all the information we need every 2 weeks. But in terms of saying whether they're good or not, it would depend what information they've reported, and it depends on their circumstances. So unfortunately, I can't tell you in your specific client's case whether they're all clear or not. So sorry if that's not the clearest answer, but unfortunately, I think it's the best I can do. Okay, and then the last change, there are temporary rules in place that exempt EI and the Canada Recovery Benefit from income assistance and disability assistance deductions. So this has been really helpful because people who did qualify for EI or the CRB got some extra money, and it didn't impact their social assistance, which was really nice. That is coming, well, right now that's set to come to an end at the end of this year. Whether it'll be extended, I don't know, but if the rules stay the way they are now, starting in the new year, EI will be subject to the usual rules. So it depends on what benefit the person gets. So for example, parental and maternity benefits and pregnancy benefits are exempt. Regular and sickness benefits generally are not, and the other benefits have unique rules. So unless things are extended, this simplicity of saying everything is exempt will end at the end of the year. And that is the end of the update. And Danielle, as usual, I took longer than I ever thought I would. I should stop saying I'll be done too quick. Are there any other questions coming in on the chat, or should I turn it over to Danielle?
There are no more questions at this time, Kevin, so you can turn over to Danielle.
All right, I'm going to try to figure out how to stop sharing here.
Yeah, thank you.
Okay, I think everyone see that okay? Great. Okay, well, thanks everyone for joining us this morning. I am going to go over housing. The way I've structured this presentation is to think about where we've been, where we are now, and where we're going. I think it's important to kind of look at all of the changes that happened over the course of the pandemic. And as Kevin pointed out earlier, we're still not out of it. So there may still be changes to come. I doubt that, but you never know. So I thought it was important to kind of look at, what measures, temporary measures were put in place and where we're sort of at now and where we may be going. So to start, there we go. Okay. To start, the first order that we had in place was the COVID-19 order, and it came into effect on March 30th, 2020. And so this order was supposed to end when the declaration of the state of emergency expired or was canceled. And a lot of the various orders and councils that we had during the course of the pandemic, earlier on in the pandemic, had this time frame for the orders to expire when the state of emergency was canceled or expired. But the reality was it didn't happen as quickly as I think government thought. So we had a lot of changes that I think were made perhaps prematurely, and then government realized that it had happened prematurely, or that they hadn't anticipated that the pandemic would last as long as it was. So the earlier orders we see having this time frame of lasting until the state of emergency expires, it was canceled, but then we see later on that changes because, again, government didn't realize how long the pandemic was actually going to last. So this first order was that order that put a moratorium on all evictions. Now, any notices to end that were provided before the COVID order 19 was effective on March 30th, remained in effect, and the RTB could still issue orders of possession. But most evictions were not permitted during this time. However, landlords could still be granted an order of possession during the time that the COVID-19 order was in place in situations where the notices to end were, again, provided to tenants prior to the COVID-19 order, a notice to end that had been given by the tenant if the tenancy was a fixed term and required the tenant to vacate at the end of the term, if the tenancy agreement was a sublease, if there was a mutual agreement that the tenancy had ended, and that the rental unit was inhabitable or the tenancy was frustrated. So again, landlords could still obtain orders of possessions in these circumstances. However, as you'll see, they weren't able to enforce the order of possession by obtaining a writ of possession from the court. So I think we had this concern that there were going to be all of these orders of possessions granted to landlords, and then once the COVID-19 order expired, or once evictions were allowed once again, and landlords were able to obtain a writ of possession, I think we were anticipating this big flood of just all of these landlords now trying to enforce their orders of possession. We didn't actually see it at class. Some of you may have seen that, but it seems like it was actually more sort of staggered as anticipated. But nonetheless, at this time, they were not allowed to evict, landlords were not allowed to evict tenants for any reason, except there was one, actually there were a couple, one being that if basically similar to an early end to tenancy. So basically if the landlord sort of met the grounds for an early end to tenancy, and it would be unfair for landlords or other tenants in the building to have to wait until the emergency order expired or was canceled. So in circumstances where that would normally warrant an early end to tenancy because a tenant maybe had significantly interfered with another tenant or landlord or unreasonably disturbed, the whole list for cause that landlords can use to justify an early end, landlords were able to do that during this time, and they were actually able to get tenants out. So this was sort of the only reason why a landlord could actually require the tenant to vacate, but that was pretty much it. And then the second one, if here landlords could apply to end the tenancy if the rental unit had to be vacated to comply with an order of the federal, provincial, regional or municipal government authority. I think, again, they were anticipating that there might be such orders, but certainly we never saw any. So I'm not aware of anyone being evicted because there was some sort of order of any level of government that would have come down during the time that the COVID-19 order was in place. And so, as I mentioned, even though a landlord might be able to obtain a writ of possession, obtain an order of possession if they provided the notice prior to March 30th, or in those other situations I explained, landlords could only obtain the writ of possession from the court in very specific circumstances. One being, when the order expired or was canceled. And again, they didn't anticipate that it wasn't going to expire or cancel in the near future at that time. Under that exceptional circumstances provision, the early end to tenancy equivalent that I mentioned earlier, if the unit was uninhabitable or if the tenancy agreement was frustrated. So basically Section 56 and Section 56.1 of the RTA, a landlord could obtain a writ of possession from the court, and the order of possession was supposed to clearly state whether it was granted under Section 56 or 56.1 of the RTA. So the court would know whether or not that particular writ was, they could actually issue a writ for those reasons. I am aware of at least one situation, though, where somehow a landlord was able to obtain a writ of possession and didn't meet any of these grounds. I can't remember the details of it. I just remember hearing about it. I don't know if anyone else had come across that situation where a tenant was still evicted and a landlord was able to obtain a writ of possession during the COVID-19 order. But again, I can't recall the circumstances, but certainly there were gaps, because as most legislation that's developed during emergency situations, it's often rushed and there are gaps. So I'm sure that one situation wasn't the only one that where a tenant was evicted during the COVID-19 order at that time. And so again, landlords who had orders of possession, if they tried to obtain a writ of possession and it wasn't the kind that they were able to obtain from the court would return the order of possession to the landlord or the tenant. If a writ of possession was granted on or before March 30th, unless the writ of possession was obtained under Section 56 or 56.1 of the RTA, the landlord could not enforce it until the COVID order expired. And a landlord or tenant who obtained a writ of possession for reasons not outlined under Section 56 or 56.1 could not enforce it. Otherwise, they could be subjected to fines or jail time. So the COVID-19 order also put a freeze on rent increases. Landlords were still able to give a notice of rent increase during the COVID-19 order, but the rent increase would not come into effect until the order expired or was canceled, unless the increase was for additional occupants and that the tenancy agreement permitted that. If a landlord had already given notice for a rent increase prior to the COVID-19 order, it was automatically canceled. And it would not come in, or sorry, it wasn't automatically canceled. It wouldn't come into effect until the COVID-19 order expired or was canceled. And if a landlord did collect an increased amount during the order, the tenant could deduct the additional amount from future rent payments. And of course, as most of us know, the rent increase freeze does not apply to nonprofit housing where rent is based on income. So the nonprofit sector, they could still increase rent. Landlord's right of access was restricted during this time as well. The landlord was not allowed to enter a rental unit, even if the landlord gave proper notice. I think there were a lot of issues that came up around this. A landlord was only able to enter the rental unit if there was an emergency in relation to COVID-19, and the entry was necessary to protect the health, safety, or welfare of the landlord, a tenant, or occupant, or guest. A landlord would have to receive consent if they wanted to enter the unit to make repairs or to show the unit to prospective tenants or to host an open house. So again, we saw a lot of folks who had issues with the landlord trying to access the rental unit and not respecting that the COVID-19 order limited their ability to do that. Also, the extension of time when a party filed for dispute resolution with the RTB, if they missed a limitation period and were asking for an extension of time, arbitrators were supposed to consider the pandemic as an exceptional circumstance. So they were supposed to be observant and mindful that a person may have missed a limitation period due to the complications that the pandemic created. So they did recognize that, and they did provide extensions of time when a party was able to explain why, and the application and the explanation still needed to be reasonable as to why they were unable to file the application or evidence within the requisite timelines. Serving documents, they made a little bit more easier and a bit more accessible. However, this was only for people who had computers or knew how to use email. They did allow for email service of all documents, and they did suspend in-person serving of documents, which of course did pose a problem to folks who didn't have computers or email addresses or weren't able to access computers, especially given this time. A lot of community centers or libraries where an individual could access a computer were closed. So despite, the RTB's attempt to introduce a new method of service that was supposed to allow for parties to serve during a pandemic, it still posed, they still didn't really come up with a solution for folks who couldn't access a computer. So documents were sufficiently served by email. And as you'll see, this is something that has actually continued to be allowed by the RTB. And so I won't get into the specifics there about, you know, when or how email service was satisfied, but there were also deemed service provisions around that too.
Danielle, there is a question for you.
Yes.
Are notices of increases dated for 22, but at the incorrect amount / annual allowable increase valid?
Sorry, is the amount of the annual increase incorrect?
Yeah, incorrect amount or annual allowable increase valid with the question mark.
Yeah, if the amount is incorrect, if the amount doesn't comply with the annual amount for 2022, which I believe is 1.5%, it would not be valid. It has to be, they have to indicate the correct amount. And as we'll see, the rent freeze actually has been extended. And so now the earliest a landlord could ask for an increase of rent would be January 2022. So if the landlord is given a notice that is effective prior to January 2022 or has the incorrect amount and is higher than 1.5%, then it would be an invalid notice of rent increase. Okay, so our next order that we got was Ministerial Order number 195, and this became effective on June 24th. So this was that dreaded order that repealed the COVID-19 order and lifted the moratorium on all evictions. The moratorium on evictions for unpaid rent continued, but by June 24th, all other evictions were able to proceed as normal. So tenants were only given a few months of relief during the pandemic. June 24th, we weren't out of it. We're still not out of it. And I think we were all sort of dreading that moment, and it came on June 24th, unfortunately. And then there were some other funny orders that came down between then and between July 31st, 2020, when the COVID-19 regulation came down, which is the last change, change to our regulation, temporary measure change. And so, yeah, there were funny things that happened in between. I won't go into them, but they had to do with, again, the government not anticipating that the pandemic was going to last as long as it was. So, you know, at that point, they were going to continue to put a moratorium on evictions for non-payment of rent until the state of emergency was expired or canceled. But then I think government realized we don't want that. We actually want to put an end to the moratorium on evictions. And that's what they did with the COVID-19 regulation. And that became effective July 31st. So July 31st 2020 is when all evictions were allowed to proceed again, including evictions for unpaid rent. There's also a policy guideline that accompanied the COVID-19 regulation. It's policy guideline 52. And there are parts of this regulation that have now been repealed, but this policy guideline is one you still may need to refer to because it outlines the repayment plan provision and it outlines what the requirements are under that. So once this COVID-19 regulation became effective, as I mentioned, the moratorium on evictions for non-payment of rent, that ended on August 18th. So effectively, tenants were expected to pay full rent as of September 1st, 2020. And tenants were required to repay the rent and utility charges that became due during what they called the affected period. So between March 18th, 2020 to August 17th, 2020, that was the period in which a tenant could not be evicted for unpaid rent. So during this period, the RTA this regulation refers to as the affected rent. So unfortunately, you know, we were all hoping that any rental arrears that would have accumulated during the pandemic or this affected period would have been forgiven. And unfortunately, that wasn't the case. Tenants were required to repay the amount back. And so a landlord could provide, so a landlord, once the moratorium on evictions for unpaid rent was lifted, and landlords could once again issue eviction notices, be granted orders of possessions and writs of possessions. A landlord could provide a notice to end tenancy for non-payment of rent that accrued prior to March 18th. So before March 18th, any rent that would have accumulated during that time, at this point, a landlord could proceed with evicting tenants. But a landlord could not issue a notice to end tenancy for non-payment of rent for the affected rent. So again, the affected rent being rent that accumulated between March 17th, 2020 and August 18th, 2020, unless the landlord had given the tenant a repayment plan for the unpaid amount and the tenant had default on the repayment plan. So a landlord could only evict tenants if they defaulted on one of the installments they had to pay to repay that affected rent. And a landlord could not try to get around things and issue a notice to end tenancy for cause for affected rent. So they couldn't claim that they were ending the tenancy for cause because the rent that accumulated during the affected period significantly jeopardized or put their property at risk, or it could not be included in the calculation of repeated late payment of rent. So really a landlord couldn't issue a notice to end tenancy for any reason for the affected rent being unpaid. Again, a landlord could only evict a tenant for the affected rent if they missed an installment in accordance with the repayment plan. And so as I mentioned, policy guideline 52 lays out the requirements for the repayment plan. Repayment plan had to be given to the tenant if they hadn't entered into prior agreements. So there could have been prior agreements that landlords and tenants had entered into. And again, the policy guideline addresses how those prior agreements will be dealt with. I don't go into them too in-depthly here, but nonetheless, just important to know that landlords and tenants could have entered into these prior agreements. And but there was this required repayment plan schedule that they needed to follow. And so the earliest a repayment plan could have been issued was August 18th. And the date the first installment was due had to be at least 30 days after the date the repayment plan was given by the landlord. Tenants had until July 10th, 2020 to repay the affected rent. So whatever amount accumulated during the affected period was sort of reduced to equal installments, and tenants only had until July 10th, 2020 to repay the affected rent. So of course, July 10th, 2021 has passed. So most tenants at this point would have either fully repaid back the affected rent, or they didn't. And if they didn't, a landlord could evict them for that. So although, again, repayment plans, unless, again, otherwise agreed to, because you can amend a repayment plan, as you'll see, to extend that time frame to go beyond July 10th, 2020. But for the most part, the repayment plans, again, absent other agreement between the landlord and tenant, repayment plans at this point are probably done. But again, it's important to, I think, be aware of these changes and be aware of the repayment plans, because you still may encounter situations where tenants are being evicted for non-payment of rent, and depending on when the landlord is claiming the rent is unpaid, you may have to refer back to some of these notices to see what was in place at that time and whether or not the landlord is able to proceed with an eviction notice. So even though we're pretty much back to status quo, you may have situations where you're going to have to go back to these various orders, go back to the repayment plan to figure out whether or not a landlord can do what they're doing, or not. So again, important to know sort of the changes, because oftentimes parties can delay filing an application for dispute resolution. And that delay, of course, could correspond to a time period where a party was either able to do something or not do something.
There's a question, Danielle.
Yep.
Are late fees during the affected period permitted?
Are late fees during the affected period permitted? So late fees can never be counted as rent. Late fees aren't supposed to be included as rent when a landlord is trying to evict a tenant for rent. That's a good question. I don't know off the top of my head. Someone else might know whether or not late fees were permitted during, it's probably in the regulation, in the COVID-19 regulation is my guess. So I think you would find your answer there, but in any event, a late fee cannot make up rent that a landlord is then going to try to evict a tenant on. But yeah, good question. I'm sorry I can't answer it, but I think you'd find your answer in the COVID-19 regulation, the most recent regulation. Okay, so again, repayment plan, so it had to be in writing. There were, my apologies, there's a garbage truck outside my window. I'll try to talk over it. Yeah, so there were requirements for the repayment plan. The date the repayment period starts had to be noted, the total amount of the affected rent that was overdue, the amount that must be paid, and the date on which each installment must be paid. And for most people, that was the first of the month, just like regular rent would be paid. So effectively, many tenants were having to pay their regular rent on top of the repayment plan installment. So it effectively, even though we had a rent increase freeze, effectively the repayment plan amounted to a pretty significant rent increase that tenants had to pay each month. Now, if the repayment plan did not comply with the specified requirements or include information that was inaccurate or incomplete, then the landlord had to give a new repayment plan that did comply with the requirements. And as I mentioned earlier, tenant and landlord could agree to amend the repayment plan, but only for the following reasons: to extend the repayment period, to change the amount payable in each installment, or to change the dates of installments if the date of the first installment is not earlier than the date of the first installment must be paid. So again, landlords and tenants could still enter into agreements to go beyond the required period to repay landlords back. And so the COVID-19 regulation, as we all know, rent increase freeze continued, but pursuant to this regulation, the rent increase was not going to come into effect until November 30th, 2020. So this was one of those circumstances where I think, again, government didn't anticipate really how long the pandemic was going to last or how it was affecting tenants. So the rent increase is sort of the only thing we're continuing to see being extended. But I think this last extension is probably the final extension, not the November 30th, because again, we all know it's been extended beyond that. And so now a rent increase can't take effect until January 2022. And I think that's probably going to be the last of it. But this was really the only thing that government continued to provide tenants as a way to easing the financial burden of the pandemic. Of course, we know this wasn't enough, but it was something that did continue. The landlord's right of access was still restricted under this regulation, but they were allowed to do a bit more than they were under the prior COVID-19 order. So a landlord could now enter the rental unit for any of the following reasons. They did have to provide proper notice, as they typically do, but they could now enter to conduct move-in, move-out condition inspection reports, monthly condition inspections, make regular repairs, or showing the unit to prospective tenants and hosting an open house. So before they weren't able to do that, even if, unless they were provided consent from the tenant. Now they didn't need consent from the tenant. They just needed to give proper notice to do those things in the unit. So prior to the COVID-19 regulation, under the COVID-19 order, a landlord could limit the amount of people who could gather in a common area. And so pursuant to the COVID regulation, they didn't need to do that anymore. They didn't need to necessarily limit the amount of people gathered in the common areas. An tenant could not request monetary compensation if the landlord terminated or restricted access to common areas, unless the RTB had already had a hearing before June 24th, 2020. So a tenant could only request monetary compensation if the landlord terminated they couldn't request monetary compensation if the landlord terminated or restricted access to common areas for the following reasons. So if they limited access to a common area to protect health and safety or welfare, to comply with an order, or to follow the guidelines of the BC CDC. So again, landlord could, based on the advice of health authorities or government authorities, limit the amount of people that could gather into a public space, and a tenant wasn't able to then request monetary compensation for loss of quiet enjoyment or having a service or facility restricted to them. Okay, I'm just mindful of the time. I'm not going to go into this too in-depthly. This you can read more about in the regulation. There's basically a section there that explains how applications for monetary orders for unpaid affected rent made before July 31st, 2020, so before the COVID regulation came into place, had to deal with when landlords are requesting an application for a monetary order. And then similarly, they also have a section in the regulation for applications for monetary orders for unpaid affected rent made after July 31st, 2020. Guest bans. So early on, as soon as the pandemic started to really hit us, we had heard that a lot of nonprofit housing providers were instituting building-wide guest bans, not just restrictions. They were outright banning the guests of tenants. Now, I think most of us know that guest bans and guest restrictions are a common issue in the nonprofit housing sector. But what we saw during the pandemic was an even more egregious attempt to control who's coming in and out of the building by just saying no guests were allowed. And of course, we know that this was very harmful to many tenants living in nonprofit housing providers. This prevented family and friends to come visit. This prevented some folks from getting food that they might have delivered to them by a friend or family member. And for the most part, it really harmed people who use drugs, because at this point they weren't, by having a guest ban, then people who use drugs weren't able to have someone with them while they were using. So guest bans were directly contrary to public health advice concerning people who use drugs. And Vancouver Coastal Health had even recommended that housing providers continue allowing visitors and use other prevention strategies so people do not use alone in their rooms. So this was a big issue. I think there was a direct correlation between the increase in overdose deaths and these guest bans that were put in place in the nonprofit sector. Now, again, I think as most of us know, building-wide guest bans and building-wide guest restrictions are not lawful. And we have that Richardson case and the PHS case that confirm that. But the COVID regulation actually stated that a landlord could not restrict guests of a tenant. So these guest bans were unlawful, and we knew that, and they were also discriminatory. So if people are still encountering this issue, I believe there still are guest bans, because again, the pandemic is not over. So I think a lot of nonprofit housing providers continue to use that as a reason to justify their guest bans. So if folks are encountering that still, we do have a letter available on our website at CLAS to provide to tenants that can then be provided to landlords that explain how these guest bans are unlawful, what a tenant's rights are, as well as, this could also be potentially discriminatory. So if anyone is helping any tenants through this or is aware of any buildings where these guest bans continue, You may find this letter helpful to just send to the landlord or to provide to a tenant that you're assisting to provide it to the landlord themselves.
There's a question, Danielle. This question, what was the other building-wide guest ban precedent case besides Richardson called, please?
Yes, so that case is called PHS and Swait. Don't know if I have time to quickly bring up the citation. Maybe find it real quick. So that, I'm trying to look it up on my phone here. So yes, so the citation for that case is 2018 BCSC 824. So that decision essentially confirms the Richardson decision, an earlier decision of the BC Supreme Court that says building-wide guest bans are unlawful. Landlords can still restrict or ban guests if they have reasonable grounds to do so, but these building-wide guest bans do not meet that threshold of being reasonable. Okay, so now we've kind of gone over where have we been, and now that brings us to where are we now? And so a lot of changes, a lot of temporary measures put in place, removed. And so where are we now? Pretty much status quo has been restored. A lot of those temporary measures have been lifted. There's not a lot left over. As I mentioned, though, you may still need to refer to the COVID regulation and the policy guideline 52, because depending on when an application has been made or when an eviction notice has been provided, you may need to look into the past to see what was effective at that time to determine whether or not there is merit to an application, or to determine whether or not there's merit to an eviction notice, or whether there are lawful grounds to pursue a particular avenue. So you may still need to do that, but for the most part, status quo has been restored. Again, aside from the fact that the rent increase has been extended until December 31st, 2021. So technically January 2022 is when notice of rent increase can become effective. And any rent increase notices issued with an effective date after March 31st, 2021 and before January 1st, 2022, they're canceled. This means the earliest a tenant can see a rent increase, as I mentioned, January 2022. However, landlord can still give a notice of rent increase prior to January 22, as long as it's within the 3 months, the requisite 3 months to do so. The notice can be provided. It's just the actual increase cannot take effect until January 2022. As I mentioned earlier, the annual rent increase amount for 2022 is going to be 1.5%. There's no more restrictions on tenants' right of access. So apart from landlords and tenants continuing to wear masks when accessing common areas and when showing the rental units, we're certainly getting more guidance from the health authorities regarding mask requirements. And so landlords and tenants are still expected to follow that guidance. A landlord can no longer restrict or schedule the use of common or shared areas, and that was effective in June 2021. And if restrictions are kept in place, a tenant can apply for dispute resolution for monetary compensation. A landlord would have to demonstrate that the restrictions are reasonable. So it's not a guarantee that a tenant would get monetary compensation if common areas or shared areas are restricted after June 2021. If a landlord, of course, can show that that restriction is reasonable, they may not be able to, they may not be successful in their request for a monetary order. No more restrictions on landlord's right of access. A landlord can enter a rental unit. Again, they are supposed to be wearing a mask. Again, for any of those same reasons, to do any inspection reports, to do any inspections, any repairs, showing the unit to prospective tenants, or having an open house, but the open house is restricted to a maximum of 6 people if the space allows. So they're still, again, expected to follow the guidance of various health authorities and continue to wear masks and continue to distance where possible. Guest bans may continue. Again, I think they are continuing. I've heard they are continuing. I don't know how many nonprofit housing providers have removed these guest bans who have had them, because again, the pandemic is very much still with us. So I can imagine that there's still probably a fair number of nonprofit housing providers who feel the guest ban is necessary. So you still may encounter situations where a tenant is living in a building where there's an outright guest ban. And yeah, which is, you know, given the harm that it causes, it's extremely concerning if that's continuing. Service by email is still permitted. I think things are a little bit different though, because I believe parties need to indicate that they will receive service by email. So at any time, a tenant or a landlord can provide an email address for service purposes. And by providing an email address, a person is sort of agreeing that the documents are going to be, they're going to accept service by email. And if an email address given for the purposes of serving documents changes at any time, the onus is on the party to ensure an updated address is provided to the other party. So as long as, you know, a landlord is giving you an email address, that's okay to serve them at that address. And if you get a bounce back or the email isn't sent, that's the landlord's onus to have updated you on that. And if they didn't, service may be seen to have still been completed because the landlord failed to meet their onus to give you the updated information. So we have some more changes, not COVID related necessarily. I think government kind of put a lot of the legislative changes they were hoping to get through in the next couple of years on pause because they had to deal with the pandemic and had to really scramble to address the pandemic. So a lot of legislative changes that they had anticipated were put on pause. They're still trying to work their way through the residential tenancy task force recommendations. So the government is still working through those. The government is still looking to implement a lot of those changes, but everything got put on pause because of COVID. However, this was put on pause, but what we are actually now seeing change is the approach to notices to end for renovations. And I know that Rob and Susanna from TREC are going to give a more in-depth session on these changes. So I'm not going to go too deep into it, but I think at this point, I just want to highlight that there is a different approach to a notice to end for renovations or renovictions, as we call them. Landlords are not going to issue notices to end for renovations and repairs anymore. So a notice to end tenancy for renovations or repair that is issued to a tenant after July 1st, 2021 is not valid because that's when this new provision came in effect. And so instead, what landlords are going to need to do is they have to apply to the RTB for an order to end tenancy and an order of possession. So the onus is not on the tenant to have to dispute the notice. It's on the landlord to go to the RTB and justify why they should end a tenancy for renovations. And so in their application to end the tenancy, the landlord has to show, again, in their application this time, that they have all the necessary permits and approvals. The unit must be vacant in order to carry out the repairs. The renovation or repair are necessary to prolong or sustain the use of the rental unit or building, and no reasonable accommodation can be made to maintain the tenancy. These last 2 points are new. They come to us because of case law. So that's what the landlord's going to have to show. And the landlord is going to have to show, or is going to have to serve a notice to end tenancy when they make this application to the tenant. The tenant is able to, again, go to the hearing, participate as they did, and provide evidence that the landlord does not meet the statutory requirements to end the tenancy. And successful landlords will receive an order of possession, but the effective date is not going to be earlier than 4 months from the date of the order. So it's a 4-month eviction. So if they are successful, whenever they receive the order, that they will be granted the order of possession, it cannot be effective until 4 months after they are granted that order. So that's a pretty big change. Also, there's a change to the tenant's compensation scheme. So previously, when a tenant applied for compensation because the landlord didn't do what they said they were going to do, and a notice to end for landlord's use, whether it's renovations or repairs, or landlords moving into the unit or family members are moved to the unit, it was the tenant's onus to prove that the landlord didn't do what they say they were going to do pursuant to the notice to end for landlord's use. So now the onus is flipped onto the landlord, which is where it should have been in the first place, because it's really difficult for a tenant to prove that. So now we have that switch of the onus when a tenant's applying for tenant's compensation for compensation that is equivalent to 12 months rent in situations where the landlord didn't complete renovations or repairs or move in as they said they would pursuant to that notice. Additional rent increases, this is another change we have. So landlords are going to be able to apply to the RTB for dispute resolution to request an additional rent increase for capital expenditures. And so capital expenditures include expenditures that are made to maintain the property, to comply with health and safety standards, replacing major systems that are no longer operative or at the end of their useful life, and those that are made to reduce energy use, greenhouse gas emissions, or improve the security of the property. And this comes to us through successful lobbying of landlords. Landlords wanted to be able to, ever since government removed that arbitrary 2% increase in rent in the calculation of rent increases, landlords were very unhappy with that. And so they lobbied government to be allowed to increase the rent beyond the annual allowable amount for these reasons.
Danielle, there is a question for you. Yes. Is class also seeing more creative notices for disturbances, breach, and other causes since and to renovictions?
Oh, sort of any creative, like attempts to circumvent the
creative
acts?
Notices for disturbances, breach, and other causes.
No, we haven't. And for those of you who don't know, at class, we don't intervene at the RTB level. We usually intervene after a tenant's received a notice. So I feel that as legal advocates, you're probably seeing way more of those types of notices than we are. We know landlords can be very crafty, very creative, and are always finding creative ways to circumvent the act, especially when there have been changes that they think affect their ability to evict tenants or increase rent. So I can't say I have seen any of those types of notice, but feel free to share with one another any situations where any of you have seen those creative attempts at landlords. I'm trying to think. I know that mutual agreements are a tool that landlords typically like to use as a way to circumvent any kind of provisions that provide security of tenure to tenants. I'm trying to think. Recently, I feel like maybe an advocate I was speaking to was telling me about a recent use of mutual agreements to end tenancy. I think there was a practice where landlords were actually having parties sign mutual agreements to end tenancy the same date they were signing their tenancy agreement. And so I believe a lot of tenants felt that they had to sign the mutual agreement. They were under duress. And so they were it was an attempt to circumvent the removal of the vacate clauses for fixed term tenancy. So that's one example of a creative attempt where they just got around it by saying, okay, if you want to live here, you also have to sign this mutual agreement to end tenancy that the tenancy is going to end on this date, and you're gonna be beholden to that. I think though, TRAC might have had a successful case at the RTB that might have stated that that's not allowable. But of course, we know RTB decisions aren't binding; they're only persuasive. But still, if you're seeing that happen, I think there is a case that TRAC dealt with and successfully argued that that was an unlawful practice in an attempt to circumvent the RTA. But yeah, off the top of my head, I can't think of any other kind of creative ways landlords are trying to get around these measures. I anticipate we're going to see a lot of attempts, especially with the new rent eviction measures. I think that I think we'll start to see some of those emerge, because we know that, you know, certainly landlords want to retain their ability to evict tenants to renovate so that they can increase the rent. So I imagine we may see some things related to rent evictions. Maybe some of you have already seen those. I don't know if anyone's dealt with that yet. It's pretty recent, but some of you may have already encountered a situation where a tenant's been given the notice of application for a landlord's request for an order of possession for an eviction. Sorry, I didn't have a good answer for you, but yeah, I think as legal advocates, you're probably seeing a lot of that more than we are at class.
There is another question kind of in the same category. So if the renovations are necessary and the tenant agrees to move out for the duration of those renovations, but wants to move back in, are the landlords obligated to let the old tenant back in? If so, is there a limit to how long a landlord can take to complete renovations?
Yeah, that's a good question. So I'm just going back a slide here because as you'll see in their application to end a tenancy for renovation and repairs, the landlord must show amongst all of these different requirements that they have to demonstrate, there's also no reasonable accommodations can be made to maintain the tenancy. So I think what is a reasonable accommodation is yet to be seen. But I think those are the kinds of questions the RTB will have to grapple with. You know, what duration of time is reasonable? If the renovations or if the renovations are only going to take about 2 weeks, is it reasonable for the tenant to move out for the 2 weeks and then move back in afterwards? So again, the goal here is to maintain the tenancy. That's the purported goal of these new rent eviction provisions, is to actually prevent them from happening in a way that isn't reasonable, or, you know, the landlord has to really show these renovations are necessary and there's no way they can be done with a tenant living in there. So I think this is one of those things that the RTB is going to probably over time develop. You know, we do have the Bauman case, the BC Court of Appeal case that did address this issue of, you know, when, you know, can a tenant move out while the renovations are being completed? And if so, is there a time frame for when it's reasonable for them to move in? And so I think this is why this is now contemplated in the Act, because it was dealt with in the Bauman case. And yeah, so I think that's going to continue to develop. I think it's been a while since I've read Bauman, but I think the Supreme Court decision was more favorable to tenants. I think, and again, correct me if I'm wrong, some of you may know better than I, but I think the BC Supreme Court level, the court did acknowledge that, you know, if a tenant moved out temporarily, you know, something like a few days or a week or something like that, and moved back in, that should be allowable, because technically you don't really need vacancy. You just need a temporary moment of vacancy to complete your repairs. So there might be a period of time where it's okay for a tenant to move out. And then the Court of Appeal wasn't so interested in those types of arguments. But again, I think this is something that will develop. I think we can probably expect that there will be situations where the repairs are of a certain duration where it would be reasonable for a tenant to just move out for that period and then be able to move back in. So yeah, I think we're going to see that become a little more firmed up now that that is a requirement that the RTB is going to need to consider, you know, whether or not that accommodation is reasonable, and whether or not, you know, having a tenant move out temporarily means that they need vacancy too, because that would also speak to the vacancy requirement. So yeah, it'll be interesting to see how that starts to develop. Yeah, and then of course we do have the right of first refusal still. It's something that I don't think too many tenants exercise, because the right of first refusal in BC is basically, after the renovations are complete, the landlord or the tenant has the right of first refusal to go back and live in the rental unit. However, the landlord can increase rent by any amount. It's not a right of first refusal at the same rate of rent the tenant was previously paying. It's right of first refusal, but at whatever rental rate the landlord wants. So I don't think we're going to see a lot of tenants, especially low-income tenants, exercising the right of first refusal, because not too many folks are going to be able to all of a sudden pay double their rent or even more. So technically there still is that ability to move back in after the renovations are complete, regardless of the amount of time it would take for the renovations to be completed. If there's an interest that the tenant wants to go back, then they are supposed to be given the opportunity to do so. But again, it could be at whatever new rate of rent the landlord wants. And again, I don't think too many tenants are going to exercise that. So hopefully that answers your question. I just have a few more slides. I'm just going to power through them. I'm not going to go too in depth, just let you know what's on the horizon. Already went over. Oh, these are complaints to the RTB. There's a whole new process. The RTB wants to be more transparent about complaints. So people who make complaints to the RTB are going to actually receive a written response now outlining the steps that were taken to review the complaint, and they're going to respond to complaints, because how many folks make complaints and then they just go out into the ether and you never hear about whatever happens to them. So thankfully now there's a more transparent, more fair process at the RTB where you should actually receive some sort of response to them. And then where are we going? The biggest changes we're going to see yet to come are the grounds for review consider will be expanded. They will include a procedural error was made by a person who performs an administrative task that affected the results of the hearing. So, if there's a procedural error made by an IO or someone who's setting up a hearing, that would be a ground. Technical irregularity or error occurred that affected the results. The arbitrator did not determine an issue they were required to determine, and the director determined an issue they were not able to determine. And so those grounds are expanded. They're going to change the grounds we already have. So rather than, a party requesting a review if they were unable to attend part of the hearing, right now it's a ground for review is if a party's unable to attend the hearing. Apparently that only applied to the entire hearing. Now it can also apply to part of the hearing. I'm not sure why they need to make that explicit. I would have thought that was a given, but and parties who request a review on the ground of new and relevant evidence have to also demonstrate the evidence would have some effect on the decision. I've seen arbitrators have already been doing that in their decisions. They've been looking for some sort of connection as to how the new relevant evidence is going to materially affect the decision. And they were doing that before that was actually legislated. So now they will actually be able to do that because it's going to be legislated. And then just some changes to the compliance and enforcement unit. They have more expanded powers about what kind of documents they can compel and request and that sort of thing. So that's it for me in terms of where we're going. And we're going to see more changes because, as I mentioned, government is still looking to implement the recommendations of the Rental Housing Task Force. So we're going to continue to see more changes, but we still don't have hearings recorded. So, and we don't know when that's happening. And I know that I think all of us are just really, really waiting for that to happen, but no sign of when that's happening yet. So thought I'd give that little update too.
Thank you. Thank you, Danielle. Thank you, Kevin. And thank you to all of you. Please have a short break. Many of you will be, I think, will be coming in the next session with Kevin as well. So thank you, Kevin and Danielle, for the great information. And we will see you soon again. Thank you.